Hello everyone, welcome to Sir UPSC Universe. I am Sowjanya, Faculty of Current Affairs. In this video, we are going to discuss one important article from the Hindu. So the article that we are going to discuss today is Cabinet gives nod to Data Protection Bill. So we are going to discuss about this Data Protection Bill in this particular video. So coming to why is it in news? The Union Cabinet has cleared the Digital Personal Data Protection (DPDP) bill recently. So the clearance of this particular bill, it will pave way for the bill to be introduced in the Parliament in the monsoon session scheduled to begin on July 20th. So Digital Personal Data Protection Bill. So this was recently cleared by the Union Cabinet. So that is the reason why this bill is in news. So we have to know the various provisions of this particular bill. So we'll look at the various provisions of this bill, an expected MCQ and also an expected mains question on this particular topic. So before that, we'll look at the syllabus relevance for UPSC. So for the UPSC prelims and for mains, what would be the relevance of this particular topic? We'll have a look at it. So for prelims, it comes under Indian polity and governance, and in terms of mains, it comes under general studies 2, important aspects of governance, transparency and accountability, e-governance, right? So it comes under GS2 for mains and Indian polity and governance for prelims. So here the most important concept in this particular article today, it is Digital Personal Data Protection Bill. So let's have a look at it. So here is our today's prelims practice question. So Digital Personal Data Protection Bill. Coming to the statements for this particular bill, as per the draft bill, courts and law enforcement agencies, they enjoy wide exemptions from key requirements. So in terms of the provisions of this bill, the courts and other law enforcement agencies, they have different kinds of exemptions from this requirements. So this is our statement 1, and our statement 2 says that it says in the Shah Bano case, privacy was declared as key to the fundamental right of life and personal liberty under Article 21 of the Constitution. So this is our second statement, and we have to identify the correct statement. Here the correct answer is A. First statement is correct and second statement is incorrect. So we will have a look at it. Why? Because it is not in the Shah Bano case. So Shah Bano case is actually about alimony. So this is one of the milestone cases of the Supreme Court in terms of the women rights of especially Muslim women. So Shah Bano case is one of the landmark judgments of Supreme Court, which is basically regarding the right to alimony for Muslim women. So coming to the explanation for this particular question, the Digital Personal Data Protection Bill, it comes after multiple versions floated by the Union government, a process that was started back in 2017. So right now, whatever draft bill that we have regarding the Digital Personal Data Bill, different versions of this particular bill, they have come out since 2017. So in 2017, we have one important judgment, that is KS Puttaswamy versus Union of India judgment. So in this case, privacy was declared key to the fundamental right of life and personal liberty under Article 21 of the Constitution. And as per the latest draft, courts and law enforcement agencies, they enjoy wide exemptions from the key requirements. Right. So whatever the requirements are provided in the bill, the courts and other law enforcement agencies, they were given some exemptions. So let's have a look at why they were given some exemptions. So these requirements, they do not apply when personal data is processed in the interest of prevention, detection, investigation or prosecution of any offense or contravention of any law, or the processing of personal data by any court or tribunal or any other body of India, which is necessary for the performance of any judicial or quasi-judicial function. So if the court needs some personal data in terms of the judicial functions or quasi-judicial functions, at that time we cannot say that court has to follow the provisions of this bill. In such cases, courts and law enforcement agencies, they would be provided some exemptions. So what is basically this personal data? So here we have this Personal Data Protection Bill. So what is personal data? What comes under personal data? So if you look at what is personal data, to be simple, this is something which identifies a person, right? So to identify a person, whatever data we use, that is what is our personal data. And this bill is regarding the protection of this personal data. So the bill itself is Digital Personal Data Protection. So this is what is personal data means. It means that data which helps us to identify a particular person, and this is how exemptions are given to court and law enforcement agencies, right? So this is when if there is some offense and some trials are going on regarding that particular offense, then for the prevention of that offense or for the investigation of that offense, if some personal data is needed, courts can use it, right? So in that way, courts and law enforcement agencies are given some exemptions from these provisions. Coming to the mains previous year question, there is a view that Official Secrets Act is an obstacle to the implementation of Right to Information Act. So RTI is one topic which is important for our exam point of view for UPSC and other exams. So do you agree with the view? Discuss. So this question was given back in 2019. So this is regarding our Official Secrets Act and then RTI, right? So this Official Secrets Act, this was enacted in the colonial period in 1923, right? So this was an act right from the colonial period, and this is a bit hindrance or an obstacle to our Right to Information Act. So this is why a question was given regarding this Official Secrets Act. So this is definitely a hindrance to right to information. So there was a proposal that National Security Act has to be brought out, so that whatever flaws are present in this Official Secrets Act, this would be reduced and we can correct those flaws in Official Secrets Act, so that RTI would be facilitated, so that the flaws in the Official Secrets Act, it would not be used to get rid of this RTI, right? So this is the question that was given. Coming to today's mains practice question, do you think personal data protection is necessary in India? So we have seen what is personal data. So it is definitely a data which can identify a particular person. To be very simple, it is that data which helps us to identify a person. So do we need to protect that personal data? So is there a need to protect personal data in India? This is the first part of the question. Second part is highlight the provisions of the recently cleared Digital Personal Data Protection Bill in this context. So this is what is our practice question for mains. So why this question? So we already had a previous year question that we have just seen, and coming to have to answer this question, what is the demand of this question? So this question has two parts. So first of all, you have to answer the necessity of personal data protection in India. Why should we protect the personal data? And second one is, the second half of the question should involve provisions of this Digital Personal Data Protection Bill. So let's have a look at how we can give a rough idea of the answer for this question, right? So this is how your introduction can be. So the introduction can be like, the Ministry of Electronics and Information Technology, it has drafted this particular bill, and a data protection law. It is a must to safeguard and balance people's right to privacy and their right to information, which are fundamental rights flowing from the Constitution. So in order to protect our right to privacy and also our right to information, this kind of data protection is definitely needed to safeguard these rights, right? And also the purpose of this bill, it is to provide for the processing of digital personal data in a manner that recognizes both rights of individuals to protect their personal data and the need to process personal data for lawful purposes, right? So whatever personal data is collected, we have to protect that personal data so that right to privacy is ensured, and also we have to process that personal data for only for lawful purposes, but not for any unlawful or illegal purposes. So it is India's first attempt to domestically legislate on the issue of data protection. So in this way, you have to introduce what is data protection, is it needed, etc. And coming to the body of the answer, you have to identify what is the necessity of personal data protection in India. So it is basically to avoid data abuse and unlawful access. So if we do not protect the data, whatever personal data of ours is collected, this can be abused and also it can be misused, and unlawful access to this data can also happen. So definitely data protection is needed. And coming to our second necessity, it is to protect the privacy of individuals. So the privacy of individuals is definitely very crucial and very important. So we have to protect the right to privacy, and also for data accuracy and for compliance with worldwide standards. So whatever standards for data protection are followed in other countries, to be in line with that, to comply with that also, this would be helpful. And also to protect from cyber attacks, to secure sensitive data. Personal data is definitely very sensitive data, so to protect the sensitive data, and also for individual empowerment. So in these ways, these are the various necessities why personal data has to be protected. So this is our first part of the question. Do you think personal data protection is necessary in India? So yes, personal data protection is needed, and these are the various necessities. So this is an example of how you can write your body of this particular answer and the first part of the answer. So coming to the second part of the answer, provisions of this bill. So firstly, usage of personal data by organizations is it must be done in a manner that it is definitely lawful, and it must be also fair to the individuals concerned and transparent to the individuals. So if our data is collected, it must be used in a fair and transparent way. And then personal data, it is to be used only for the purposes for which it is collected. So if my personal data is collected for a particular task, so only for that it has to be used. It must not be used for other things, right? So for whatever purpose it was collected, only for that purpose the data has to be used. And the third principle says regarding data minimization, and the fourth one is it puts an emphasis on data accuracy when it comes to collection. So first of all, we have to know the purpose of data collection. Why are we collecting the personal data? And we have to stick to that purpose. Only for that purpose we have to use the data, so that accuracy must be maintained. And coming to the next principle, it talks of half personal data that is collected cannot be stored perpetually by default, and storage should be limited to a fixed duration. For example, our personal data is collected for a purpose and it has been also used only for that purpose. What next? It has to be only stored for a fixed duration. So for example, it has to be stored for only 1 year, right? So in that way, for a fixed duration, it has to be stored. After that, it should not be stored, right? And coming to our next principle, sixth principle says that there should be reasonable safeguards to ensure that there is no unauthorized collection of or processing of personal data. So only authorized collection has to be done, and it has to be used only for lawful purposes. It has to be transparent and fair, and also it must be used only for that particular purpose for which it was collected, and it should be only maintained for a particular fixed period of time. And next principle says that the person who decides the purpose and means of processing of this personal data, that person should be accountable for such processing, right? So for example, if government orders the collection of personal data, so it should take the accountability or responsibility for that particular collection and processing of that particular data. And the bill ensures that individuals should be able to access basic information in languages specified in the 8th schedule of the Indian Constitution. So not only in English, so the personal data which is collected, it has to be available in all the languages specified in the 8th schedule of our Constitution. And individuals need to give consent before their data is processed. So consent is definitely very much needed, right? So without our consent, our personal data must not be collected. Only after taking the proper consent of the individual, data could be collected. And individuals also have the right to withdraw their consent, right, from a data fiduciary. So here we have data principality and data fiduciary. So data principality is the person whose data is being collected, and data fiduciary is, it can be a company or a firm or an individual, and this data fiduciary has to set the standards like how this can be used, how the data has to be processed and used, and for how much time it has to be stored and all, right? So consent and also withdrawal of consent, both are needed. So for an individual, for their personal data to be collected, if my personal data has to be collected, I have to give my consent So I have to say yes, you can collect my data, right? And also, if I think that the purpose has been fulfilled with my personal data, whatever, for whatever purpose it was collected, if that purpose is fulfilled, I can definitely withdraw my consent. So earlier I have said, okay, yes, I'm agreeing to you taking my personal data. So now, as the purpose is finished, I'm withdrawing my consent. So this is have the right to consent and the right to withdraw the consent, both are given to the individuals. And the bill also proposes to set up a data protection board to ensure compliance with the bill. So if any agency or a firm which has collected the personal data, it is not complying with the bill, what would happen then? It could go to this data protection board that was set up, right? So this is our second part of the question, and finally coming to the conclusion, personal data protection, it is definitely necessary in India. So do you think it is necessary in India? That was the question. So you have to say, like, if you are agreeing with it, you have to say like, yes, the personal data protection is necessary in India, and we have already given the reasons for it. But however, some caution is definitely needed. So what is this particular caution that has to be followed? Putting in too much focus on safeguarding such data, it is counterproductive. Why? Because it inhibits innovation, it limits corporate development, and also it impedes public services, and it also reduces competitiveness. So this is one caution that has to be followed while collecting this personal data and providing a protection for this personal data. As a result, India needs definitely a balanced approach. So for definitely any initiative taken by the government, a balanced approach is definitely needed, right? So for even data protection also, a balanced approach is needed. It may yield various advantages by safeguarding individual privacy while supporting innovation, research and development. So then what will happen? Businesses, it will also function smoothly and normally, and it will also boost investors' confidence. So when personal data is properly protected, then it will definitely boost the confidence of the investors, and it will help India become a leader in the global data economy. So overall, it will result in a more sustainable and reasonable and responsible use of data, and this will benefit all the stakeholders. So this is how you can introduce your answer, and this would be your body of the answer and the conclusion. So this is what is our mains practice question. Coming to the detailed explanation of important concepts, digital personal data bill. So we have already seen some provisions of this particular bill, right? So the data protection legislation, it specifies norms on management of personal data of Indian residents, and it requires explicit consent from the people whose data is collected and used. So as we have discussed earlier, this digital personal data protection bill, this bill is regarding the protection of personal data, and as we have discussed, personal data is a data which helps us to identify a person. So definitely this particular bill is needed to provide protection to the data or personal data of the people, and before using it, consent of the persons is also, and the individuals is definitely needed. So if our individual's data is collected and it is being used, the consent of that particular individual is needed, and it allows lay persons to complain to a data protection board. As we've already discussed, if there is any firm or company who is collecting this personal data, if they are not complying with the provisions of this particular bill, the persons who are aggrieved persons, they can definitely approach this particular board, that is data protection board, right? So we have provisions of the bill, we are going to follow the provisions. If there is any non-compliance of this provisions of this bill, what should we do? We can approach this data protection board. So this will consist of technical experts constituted by the government, right? So the board will constitute an investigation into the breach. So if you say that, okay, my personal data, it was breached, and if you approach the data protection board, it will have a investigation into how that breach has happened, what else has happened regarding the breach of personal data. So this bill also outlines practices for entities that collect personal data, and also how that data has to be stored and processed. So how should they collect? How should it be stored? how should it be processed, how should it be used for properly for that particular purpose for which it was collected. All these are outlined in this particular bill, right? And we were inspired from the EU law, that is General Data Protection Regulation, right? And this is the has also given some benchmarks of 23 instances in which taking consent of recorded data is not possible, right? In some special circumstances, taking of this data may not be possible, like for example golden hour during an accident or natural disasters, etc. So at that time these are some special circumstances where recording the data is not possible. So the bill also has a clause for offering voluntary undertaking in case an entity wants to admit that a breach has occurred and paying penalty as mitigation measure to avoid court litigation, right? So if a person's personal data is collected and there is a breach of that personal data, he can approach the court, and if he feels that I do not want this court litigation, then he can ask for payment of a penalty for this particular breach. So this provision is also provided. So in case they want to go to the court, they can go to the court for this litigation, and if they do not want this court litigation, to avoid this court litigation, they can go for payment of a penalty. They can ask for this payment of penalty if there is a breach of their personal data that is collected, right? So penalties can even reach up to 250 crore rupees for each instance of breach, ranging up to 250 crores, and an upward revision of 500 crores can be made. So this is what is the upper slab for the penalty amount, right? And as per this draft, Data Protection Board of India, so it could fine firms which do not protect user data with fines for individual offences ranging from 10,000 rupees to 500 crores, right? So if data is breached, so there is a penalty right from 10,000 rupees to we have 500 crores, right? So this could be the penalty for breach of personal data, right? And also, as we have discussed, courts and law enforcement agencies, they were given some exemptions, because if there is any investigation going on regarding any offense that is committed, and if the investigation needs personal data of a person, then they can definitely access that personal data. And in those times, in those special circumstances, these courts and law enforcement agencies, they are provided a exemption from the provisions of this particular bill. And RTI activists, they have raised concerns on the amendment to RTI Act of 2005. So this would prohibit the government departments from sharing personal information, arguing government departments may refuse to share this information that could hold public officers accountable. So on the other hand, RTI, Right to Information activists, they say that after this particular bill has come up, right, it may then government officials and government departments, they may refuse to share the information. So this is one concern of the RTI activists. So this is all about our digital personal data protection bill. So we have discussed what are the principles and provisions of this particular bill. We have also discussed a prelims practice question and a mains practice question on this particular topic. So hope you have had a clear view of the entire article which is in news today. Hope you have liked this video. Thank you.